subpoena, ducis tecum, which is a post-judgment subpoena, asking you to produce the paperwork the client provided you. Doesn't happen very often, but I, as a creditor's attorney, have done that. My clients, my banking clients, when I was representing the banks, they would typically and periodically pull credit bureaus on clients, on people that owed them money. And they'd be monitoring to see if there's any recent inquiries. As soon as they see that there's an inquiry, and if it's a real estate office, boom, they notice up. If it's post-judgment, they notice up the real estate office for a judgment debtor's exam. Tell them the real estate office or the broker, bring that file with you. We want to see what's in there. You know, so that's a risk. That's kind of a risk that you run. But if the client did lie, did make misrepresentations on that loan application, or if he has a lot of assets, you have to ask yourself this question: do we want to make financial disclosure? There is risk. Who gets to determine whether or not the client's going to assume that risk?
The client.
The client. It's the client's decision. It's not ours. If the short sale is denied, or if the lender says, yeah, we'll go along with the short sale, but we specifically reserve the right to sue. Have you just exposed the jugular? Yeah, you have. Yeah, you have. If you're going to do a short sale, make sure you get a written agreement with the lender.
Signed.
Signed! Love that word, signed. Ladies and gentlemen, learn the statute of frauds. There is something out there called the statute of frauds. Know it, live it, incorporate it as part of your being. Any agreement that touches or concerns real property must be in writing, and it must be signed by the party against whom enforcement is sought. There's a case. It's the Seacrest case. Actually, I think I give the citation here in a little bit. But there's a Seacrest case, and I think it's in another slide, but it was in 2008, I believe, in November of 2008, the 4th District Court of Appeals, which is the Court of Appeals that oversees the state courts here in, Superior Courts here in San Diego, held, it was a case where a homeowner modified his loan with the lender. The lender prepared the loan modification. The lender provided the loan modification to the homeowner. The homeowner signed the loan modification. The homeowner fully performed on the loan modification. The loan was assigned. The bank sold it to a new bank. The new bank sold the property. Surprise! Right? And the homeowner naturally is saying, well, wait a minute, foul, time out, foul. I have a deal. We got a loan modification. The bank agreed to it. Look, I got a piece of paper. I signed it. I paid. You can't sell my property. 4th District Court of Appeals. Or the bank. Here's what the bank's argument was. Yeah, we can. We didn't sign it. We didn't sign it. The 4th District Court of Appeals sided with the bank. They said, you're right. You did not sign it. The statute of frauds says any agreement that touches or concerns real property must be in writing, and it must be signed by the party against whom enforcement is sought. Kind of important to know that now, isn't it? The the homeowner in that case lost. It's kind of important now to know what you're doing. Right? Okay, now, if you're going to have a short sale agreement, what are you going to make sure you get from the lender? What's that? An agreement in writing, signed by whom? The lender. Both. All good answers. All good answers. No signature, then what? No deal. No signature, no deal. Okay? Watch out, ladies and gentlemen, for what I call exculpatory provisions. Exculpatory provisions. Those are cover my derriere provisions. I've seen many lenders squeeze in these exculpatory provisions. These exculpatory provisions are basically provisions that say the homeowner or the borrower thereby waives any and all claims that he may have, whether he knows about them or not, that may presently exist against his lender. I call that jockeying for position. I call that jockeying for position. Now, given that the lender is not getting paid, usually in a short sale, can we credibly expect the bank to behave any differently? No. No. Anticipate it. They're jockeying for position. They're taking a haircut. They're taking a financial hit. Expect them to jockey for position, because if somebody were trying to stiff you for some money, that's exactly what you would do. You'd be coming to me in my office and saying, I want to get this guy, he owes me money, he's not paying. What can we do to get my money? Tax liability. Tax liability. See what the lenders are going to do with regard to the 1099. What dollar amount are they going to use in the 1099? See what you can do. Make sure that it's signed by the lender, and make sure that the wording in the short sale agreement is adequately worded. Unfortunately, I don't know a way around it, and I know it sounds self-serving, but I don't know a way around it. You're going to have to get a lawyer involved, eyeballing that thing to make sure that it's adequately worded, because what you are doing in a short sale is you are replacing statutory language that has withstood the test of time with contractual language that is being prepared by the adversary. I don't know a way around it. I wish I did. And caution, stated income loans. What's another name for stated income loans? Liar loans. Liar loans, that's right, liar loans. Watch out for them, ladies and gentlemen. I don't know the statistic as to what percentage of stated income loans where the borrower's actually misrepresented their financials. But gosh, of the people that come into my office, it is by far the majority. And if I had to put a number on it for the people that I see, maybe it's 2/3. It's a lot. It's a lot. Well, hold on. Do me a favor with the questions. I'm almost done. Write the questions down, and I will stick around afterwards, and I will answer everybody's questions. I promise. I promise. Okay, now, remember, the creditor-debtor relationship is not the only adversarial relationship here. What about the seller, who you are representing in a short sale? What about his relationship with the buyer? What's in the buyer's best interest is he gets the lowest price possible. What's in the seller's best interest he gets the highest price possible. Those two interests are mutually exclusive. There's inherent conflict there. Now, what we're starting to see now is buyers are getting extremely frustrated, especially if they're families. You guys know a lot of the buyers and sellers are their families. They're moving into a neighborhood because it's a new school district. They want to close escrow before the school season or the school year starts, so the kids get a fresh start with the school year. Blah blah blah. And when things are dragging out, as you have seen with these short sales, they drag out a long time. The buyers get frustrated. And then here's where problems start, because you've got different people exercising their discretion contrary than